Good morning. My name is Lucy Thomson. I'm the founding principal of the Livingston law firm in Washington, D.C. I focus on cybersecurity, global data privacy, compliance, and risk management. I'm also a former federal prosecutor, and I can confirm that being in court is the last place you want to be, particularly if you or your clients have suffered a major data breach in which critical data was lost, stolen, altered, or is no longer available. The agenda for this program will focus on risks you can avoid to stay out of court. We will begin by looking at how the intelligence community assesses cyber risks, and then look at evolving laws and standards that apply to the storage industry. We'll take a look at a few cases that illustrate the issues faced by companies that failed to meet the standards. And then we'll try to understand how the regulators think. Finally, we'll answer the question, is your storage security reasonable security? We'll start with the intelligence community's assessment of cyber risks. Every year, the intelligence community publishes the annual threat assessment. And look at what they said in 2021, that cyber threats from nation-state attacks remain acute. Foreign states use cyber operations to steal information, influence populations, and damage industry, including physical and digital critical infrastructure. We're coming up on the one-year anniversary of the White House executive order on improving the nation's cybersecurity, which is Executive Order 14028. And the executive order echoed the findings of the intelligence community that cyber attacks threaten the public sector, the private sector, and ultimately the American people's security and privacy. Everyone in the storage community knows that the attack vectors leading to major cyber attacks are not always obvious. One major attack against a casino in Nevada was launched through a fish tank thermometer. And we all know about mobile devices such as smart IP cameras being the entry point for compromise of entire networks. The annual threat assessment from this year is pictured on this slide, but let's go back to 2018 when the intelligence community focused on IoT devices and said the potential for surprise in the cyber realm will increase in the next year and beyond as billions more digital devices are connected with relatively built-in security. Ransomware and malware attacks have spread globally. So this is where you come in. Just think of all the billions of devices that you as a storage industry expert create and implement and sell and use. So drilling down on the findings of the 2022 Intelligence Community's report, they focused on the four countries that are most often responsible for the major cyber attacks. They talk about China as disrupting critical infrastructure and focusing on oil and gas pipelines. Russia targets critical infrastructure, including undersea cables and industrial control systems. Iran has made aggressive cyber attacks against the US and Israel that threaten major networks and data in both countries. North Korea responsible for the famous Sony attack, has focused on a range of industry sectors, including media, academia, defense companies, and governments. In addition to these nation states, we need to focus on transnational cyber criminals that are responsible for launching many of the malware attacks. And those attacks have often focused on operations that lack resilience or consumer organizations, entities that cannot sustain service disruptions, such as hospitals, where ransom attacks can shut down entire systems of medical records. So think about the industry sectors where you work and what can be the impact of these cyber attacks, and what can you do in your storage systems to help prevent these attacks. One use case involving China is particularly interesting to illustrate the problems. Mandiant last month notified everyone that Chinese hackers were responsible for breaches of 6 US state governments. And you may think, well, what's the problem? We hear about data breaches every day. But let's look at the backstory to these Chinese hackers. In September of 2020, the Justice Department indicted 5 Chinese nationals for cyber attacks. And they facilitated the threat of source code, software code signing certificates, customer account data, and valuable business information, and were responsible for ransomware and cryptojacking schemes. The important thing about these attacks is the broad scope of the organizations and entities that were affected. 100 victim companies in the US and abroad. And look at this list: software development companies, computer hardware manufacturers, telecom, social media, video games, nonprofits, universities, think tanks, and foreign governments. It's likely that you will be working with many of these types of organizations, and that the storage media you develop will be the linchpin for security for these types of organizations. So you're in the center of these issues. This slide is labeled warning, and that's because the security standards that apply to the storage industry provide notice of the threats and risks and potential liability that can flow from these types of cyber attacks. Look at the common compliance issues involving storage systems and infrastructure specifically. These are laid out in the ISO 27040 document that you'll be discussing this afternoon in some detail. This is quite a comprehensive list of areas, problem areas for storage systems and infrastructure. And they cover the typical CIA triad types of vulnerabilities, including unauthorized access and disclosure, theft or loss of storage media, unlawful transfer of data, non-conformance with policies such as sanitization, data retention and protection, insufficient evidence of security such as audit logs and proof of encryption, integrity problems, corruption or modification and destruction of data, and the malware and DDoS attacks that we've discussed. So organizations, the document says specifically, organizations can incur significant liabilities and penalties for non-compliance, and that can lead to costly sanctions and remediation. Another reason this is important is because if you or your company or your clients end up in court, notice is an important element of a charge under a statute. And ignorance of the law is no excuse. But if a prosecutor can say that a defendant had notice of the threats and risks and potential liability and didn't take action to address them, that person's case is far stronger. So this is an issue to think about as you develop your storage systems. So now that we've understood that data breaches and cyber attacks will happen, and that storage security is integral to the security of all of these industry sectors and critical infrastructure that were called out by the intelligence community, and the threats and risks are substantial, let's take a look at some of the laws that apply and focus on the question of reasonable security, because we've all heard that phrase bandied about, but what does this really mean? One starting point are the state data breach notification laws. In all 50 states now, and DC and the territories, they all have laws requiring companies to notify individuals of security breaches of their personally identifiable information. But in addition, 25 of these states have laws, broad data security laws. And what these laws require is that companies implement and maintain reasonable security procedures and practices appropriate to the nature of the information and to protect the personal information from unauthorized access, destruction, use, modification, or disclosure. That's a very broad statement. So what does this really mean in practice? Here is an overview of some of the patchwork of privacy and security laws that have been passed in this country. They focus on certain highly regulated industries, such as healthcare, financial, and telecom, and certain groups such as children who are protected. You're all familiar with HIPAA, the Health, Security, Privacy, and Security Rules, and Gramm-Leach-Bliley, which is the protection of financial institutions and consumer data. And then in the US states that we discussed, there are many other laws besides data breach notification. Some of them are very specialized. And then internationally, the most well-known is the EU General Data Protection Regulation, GDPR, which is a very broad statute with substantial penalties for violations. So these are the laws that you need to be familiar with so that you'll know what the requirements are that pertain to your work in the storage industry. A couple of things to highlight. For financial institutions, there are new security safeguard rules. The Treasury Department and other government agencies that regulate banks have standards that require banks to develop, implement, and maintain reasonable administrative, technical, and physical safeguards to protect the security and confidentiality and integrity of customer information. So again, we see this concept of reasonable security set forth in a very broad way. And then new FTC standards that were just issued last year for customer information maintained by non-bank financial institutions. And you can see this list is very detailed and prescriptive. So in the laws, we have the general reasonable security requirements, and then recently, many prescriptive laws have been enacted that have more specific requirements that you'll need to take into account as you develop your security products and services. So what is reasonable security? The courts and industry regulators have settled on the idea that reasonable security is a process, which means that you and your clients and your companies need to follow this process in order to ensure reasonable security for the organization that you're working with. So the first step is to assign responsibility for security, someone in the company that's the point person. Then identify the information assets to be protected. This is a security 101 requirement. Obviously, you can't protect a device or software if you don't know about it. Then conduct a risk assessment to identify the threats, vulnerabilities, and risks that may be present in the environment where you're working. And then use an appropriate security framework to conduct an assessment. So a couple of examples are the ISO 27000 series that you'll be discussing this afternoon, the top 20 controls by CIS, or the many NIST 800 special publications. And then select, develop, and implement appropriate controls based on the security analysis and the risk assessment. Don't forget to address third-party vendor issues. We all know that data breaches often occur. Entry into large companies are through the weaker and smaller business partners and third-party vendors. We see this all the time. So third-party risk is a huge problem. And then educate and train employees and business partners. This is particularly important as we know that phishing attacks, when employees click on emails, can lead to massive ransomware attacks. And then continuous monitoring. Regularly review and reassess the security products that you're providing and how well they match up with the threats and risks, and adjust the security as needed as the program goes forward. You're probably aware of the NIST Cybersecurity Framework, which is a voluntary framework that's been widely adopted by companies and governments around the world. This framework sets forth the same type of process that we just discussed for reasonable security, and it helps to mitigate risks and keep you out of court. And you can read all the NIST documents and see the various steps to take and follow them to mitigate your risks. So now let's turn to the practical realities of ending up in court. And this happens when the regulators look at major data breaches and become concerned about whether reasonable security was applied and why the breach occurred. The most well-known entity that regulates security is the Federal Trade Commission. The Federal Trade Commission Act gives the FTC the authority to bring cases involving unfair and deceptive practices. And we'll look at some of these cases, and you'll see the issues that these companies ran into with the FTC. The Securities and Exchange Commission issues requirements for public companies to disclose cybersecurity risks, and we'll see a new requirement just issued. The Department of Health and Human Services Office for Civil Rights focuses on security and privacy of healthcare providers. And they have stepped up their enforcement greatly and have imposed million-dollar penalties on healthcare providers who failed to protect healthcare records. The Justice Department brings cases against hackers and for violations of the Computer Fraud and Abuse Act and some other statutes. Every state has an attorney general, and these attorneys general have been very busy enforcing these state data breach notification and security laws, as well as consumer protection. So you need to be well aware of what they're doing. And then following the passage of GDPR, the European Union has set up a very aggressive data protection enforcement regime where they levy huge fines, as we mentioned before, on companies around the world that don't comply. Let's take a look at some of the cases involving the FTC and their charges of unfair and deceptive practices for security violations. The remedy when the FTC finds a violation is to require companies to implement comprehensive security and privacy requirements, quote, reasonably designed to address security risks. And they often impose huge fines in addition to long-term monitoring by third parties, such as the fine against Equifax for $575 million. So these cases are examples of FTC cases that involve storage security, devices, systems, products. So on the left, these cases involve storage devices that had insufficient security, such as HTC America and its smartphones. In the TaxSlayer case, hackers accessed thousands of financial accounts from some sort of computer or storage media. And the FTC found violations of the Gramm-Leach-Bliley Act that we mentioned earlier that governs financial institutions. The cases in the middle on this slide have to do with hardware security flaws. The first one, Asus Tech, involved critical security flaws in routers that put home networks of thousands of computers at risk. The next two cases involve false misrepresentations by companies concerning security. And this is a theme that the FTC pursues all the time in security and privacy cases, where a company represents that its device is secure and it really is found to be not. So in D-Link, they failed to take reasonable steps to secure their wireless routers and internet-connected cameras. TapLock falsely claimed that its internet-connected smart locks were unbreakable and secure. And then in the right-hand side, these two cases involve software. BLU products involve software on consumers' devices that transmitted personal information to third parties without their knowledge. And Lightyear Dealer involved an auto dealer software that the provider failed to take reasonable steps to secure consumers' data. So you can see from these cases the wide range of issues that the FTC addresses and the trouble that many companies have been in for failure to address the risks that they should have identified. The SEC has just in March proposed a broad rule involving cyber risk management, strategy, government, And this is an area involving all public companies where I'm sure you'll be asked to assist these public companies in their new reporting requirements, and also to make sure that the security that you're developing is appropriate and robust for these companies. They have to report within 4 days material cybersecurity incidents, and then public companies have to do periodic reporting about their policies and procedures to identify and manage cybersecurity risks. And they also have to do annual reporting about the cyber expertise of their board of directors. So this proposed rule is out for public comment, but keep this on your radar because you may be very involved in these reporting requirements. Another example is a federal law passed last year called the IoT Cybersecurity Improvement Act, which Congress directed NIST to issue recommendations for the security of IoT devices, which is directly within your ambit. NIST issued special publication 800-213 in response, which focuses on requirements for secure development of IoT devices, identity management, patching, and configuration management. And then Congress also organized work in the vulnerability management area, which is an initiative that NIST has been focused on. State laws are focused on defining IoT reasonable security requirements. There are two laws, California and Oregon, have undertaken to create minimum security requirements for these IoT devices. And they define reasonable security features very broadly. And these three elements are what applies to your work in the storage industry. The reasonable security must be appropriate for the nature and function of the device, appropriate for the information the device collects, contains, or transmits, and designed to protect the device and any information contained therein from authorized access, destruction, use, modification, or disclosure. So think about, what does this mean? And especially in terms of the products and services you're designing for storage. So what happens if you end up in court? There's a couple of issues here. This afternoon, you'll be discussing the updated storage security standards that were just published this year by ISO, NIST, and PCI pertaining to credit cards. The question is, will these new standards of care, which are quite robust, become a new standard of care for cyber litigation? So let's look at how a data breach case is won or lost in court. If an individual who suffered a data breach or the FTC brings a case, they'll be alleging failure of a company to exercise reasonable care that may need to lead to liability if such failure caused an injury. So that's, there's 4 elements in the case that must be met. And the first one is a duty of care. And that means what type of reasonable security should have been used by the company when the data breach occurred. And the law defines it as the level of care that a reasonable person would exercise in the circumstances. And it's very likely that industry standards, particularly those for the storage industry, would be a guidepost. And then you would have, in the case of breach of duty, which would be a data breach, harm or injury to the plaintiffs and causation. And if you look at this list of potential people who could be responsible for a breach, there's a wide range, including developers in the storage industry, as well as manufacturers, sellers, tech integrators, data owners. And in the storage industry, this is particularly complicated because you have the devices themselves, the network, including the supply chain, and the IoT infrastructure where these devices and media are implemented. So this is a very important area to keep in mind as you consider the laws and standards that you need to follow. So now we consider the key question: is your storage security reasonable security? And this is the takeaway from this program. And here are some action steps that we've discussed that should be followed when you leave this program. Understand the cyber threats and risks. Follow security and privacy by design. Build storage security into the business model and the infrastructure. Develop plans to comply with the most restrictive laws and security standards. Because there are so many, it's strategic to focus on the most restrictive. Then follow the well-accepted process for reasonable security that we discussed earlier. Make sure that you document all the steps that you've taken. Conduct a risk assessment and document the findings. Focus in particular on the third-party vendors and business partners because they can be the weak link. Secure your supply chain. And Executive Order 14028 covers several important issues: software bill of materials, information sharing, zero trust architecture. These are themes you'll want to consider. And then continuous monitoring of the legal landscape and the requirements for security storage systems and infrastructure. Here are some resources you may find helpful. The American Bar Association, where I'm active, has published 2 books. I was the co-editor of the Internet of Things book, which focuses on legal issues, policy, and practical strategies. And the Cybersecurity Handbook, 3rd edition, is coming out this month. Both of these books focus in depth on the legal and policy issues, as well as some technical assessments that you may want to follow up on. And then here's a list of many of the documents that are important for establishing industry standards for reasonable security. I'm happy to answer any questions you may have. Just send me a note at the email below. Please take a moment to rate this session. Thank you so much for attending the SNIA Storage Security Summit and this program. And I hope you have a great day.